When a person dies, his or her property does not just automatically get transferred to their heirs. That's why it's important that you know what to do after a parent passes away. I'm a lawyer, and in many Filipino families, parents pass away without a last will and testament. The house is still standing, the land is still there, but who really owns it now? Well, in this situation, the rules of intestate succession under Philippine law shall govern. Under the Civil Code of the Philippines, it says that when a person dies, leaving no will, the rules of intestate succession shall, in the absence of any other provision by law, govern the order of succession to the property of the person who has died. Now, how does this work? Who inherits first? According to Article 977 of the Civil Code, the following are called to inherit the intestate estate of a person who dies leaving no will. First, the surviving spouse, if any. Second, the children and their descendants. Third, the parents and their descendants. Fourth, the brothers and sisters and their descendants. Fifth, the relatives by blood of the second degree. And sixth, those of the third degree. So if your parents die with no will, and they are still living together as husband and wife at the time of their death, then their estate, including their house and land, shall be divided first between their surviving spouse. If there's no surviving spouse, then their estate shall be inherited first by their children and grandchildren. Now, what if there are no children? Then the parents shall inherit the property first. But what if both parents have already passed away? Well, then it's the siblings who shall inherit the property. There are instances, though, when a child pays for the repair of the house. Does this mean that the house automatically belongs to him? Not necessarily. Under Article 851 of the Civil Code, the following shall not be considered as donations, even if made in a public document. A. Payments of a debt. B. The ordinary expenses of the family. And C. Support given to ascendants, descendants, or relatives by the amount due them, by law or by custom. Even if only one child paid for the repair of the house, this would not automatically make him the sole owner of the house, because it was probably an ordinary expense for the benefit of the family. But if he can prove that he paid for the repair of the house with his own personal funds, and not with money that he borrowed or with money that was supposed to be for the benefit of the family, then he may have a claim over the house, but not necessarily the whole house. He may be entitled to a share equivalent to the percentage of the repair that he shouldered. What if the parents have a surviving spouse and children from another relationship? For instance, a legal wife and an illegitimate child. May the illegitimate child claim a share of the inheritance from his parents? Yes, he may. Under Article 296 of the Family Code, an illegitimate child shall have all the rights and be entitled to all the benefits, privileges, and exemptions granted to legitimate children. Thus, even if only one child is legitimate and the others are illegitimate, the illegitimate child cannot be deprived of his or her share in the inheritance simply because he or she is illegitimate. What if the parents have a surviving spouse and children from another relationship? For instance, a legal wife and an illegitimate child. May the illegitimate child claim a share of the inheritance from his parents? Yes, he may. Under Article 296 of the Family Code, an illegitimate child shall have all the rights and be entitled to all the benefits, privileges, and exemptions granted to legitimate children. Thus, even if only one child is legitimate and the others are illegitimate, the illegitimate child cannot be deprived of his or her share in the inheritance simply because he or she is illegitimate. The same thing if the parents have a stepchild. Under Article 297 of the Family Code, stepchildren shall be considered as legitimate children for all purposes except for the right of inheritance. However, under Article 853 of the Civil Code, illegitimate children shall not be considered as members of the family for the purpose of intestate and testamentary successions, meaning they can already receive a share of the inheritance. To claim one's inheritance, what documents are needed to transfer the ownership legally? One must go through probate proceedings in court. It's a lengthy process which may take several months or even years. First, you need to prepare the necessary documents such as the death certificate, tax clearance, marriage contract, birth certificates, among others. Then you need to file a petition for the probate of the will or for the administration of the intestate estate. You need to publish a notice of hearing in a newspaper of general circulation. Then you need to wait for the court to set the hearing. After the hearing, the court will issue an order admitting the will to probate or an order of intestacy. With this order, you can now transfer the property under your name. Otherwise, if you don't have the order of the court, the transfer of the property may be considered as a donation, which is subject to donor's tax. So as you can see, it is very important to plan ahead. It is always better to have a will, so that you can avoid your family from going through all these problems and expenses. If you want to know more about estate planning, check out my other videos about the different estate planning tools. You may also comment down below if you have questions, and I'll try to reply to all of them. That's all for today. If you like this video, please hit the like button and subscribe for more legal information. Also check out our other videos that may interest you. Once again, thanks for watching, and see you in the next video.